I thank the gentlewoman for Wyoming. The gentlewoman from Oregon, who's been sitting here diligently, is now recognized for her time.
Thank you so much, Mr. Chair. I honestly am not sure that we are talking about the same law here, because I'm stunned that my Republican colleagues want to limit people's ability to challenge our government to have access to justice. If the government is breaking the law, failing to implement and enforce laws passed by Congress, then it is our job to make sure we are the representatives that people have access to that justice. So I also want to just point out that this rampant abuse that's being called out accounted in fiscal year 2024 for 11 awards from the Department of Interior and 11 from USDA, totaling $3.5 million. SSA, 10,000 Social Security cases, 10,000 awards, $60 million to our Social Security recipients, and veterans receive 6,000 awards. We can't just choose to close off one part of the justice system and leave that open for others. It is absolutely mind-blowing to me that we want to somehow change this law so that we can not allow folks to bring environmental cases and then close it for all others. I also want to just underline that permitting and the delays, that is absolutely something that we are talking about and is a desire that is bipartisan for us to fix. But I will continue to assert that our understaffing of our agencies leads to a lot of the cases that we are going to talk about here. If we understaff agencies, put them under stress, and then we tell them that it's their fault that they made a mistake and the government has to pay, that is on us. And so, Professor Rolfe, I know that we've talked about this a little bit, but I'm hearing so much about the rampant abuse of environmental groups. I'd like to understand, what are the safeguards? And I know that we've highlighted these, so just briefly, what are, again, the safeguards built into EAJA, created by case law, that protect against it being abused?
There are several safeguards. First of all, as we've already discussed, EAJA only allows for fee awards to prevailing parties. So if a party demonstrates in court with a high standard, judges have to find that decisions by federal agencies are arbitrary and capricious. Only then can a plaintiff even seek fees under the Equal Access to Justice Act. At that point, the court still has to find that the position of the federal defendants was not substantially justified. So another standard, another hurdle, and only after surmounting both of those is a party eligible for a fee award.
And I'm sorry to be redundant, but I think it's really important that these plaintiffs have to win, meaning that they're not frivolous by definition. So again, to Professor Rolfe, chronic underfunding, as I was just talking about, at the Department of Interior and the U.S. Forest Service results in mistakes and delays. To what end, or please describe for us, how many of these lawsuits tend to be generated by those deadlines being missed or delays being had, and staffing being a challenge in my mind? Do you feel like staffing the agencies appropriately could mitigate the risk for these lawsuits?
Absolutely. As I explained, deadlines and procedures are very important in environmental law. One of the reasons that agencies chronically miss those deadlines and don't comply with those procedures is they simply do not have the funding and the personnel to do the jobs that Congress has handed them. And the fact that today we're talking about figures like $24 million from 2 departments in the federal government, I mean, that is a drop in the bucket. If you look at what has happened to federal agencies just this year, their budgets have been decimated. Their personnel have been decimated and laid off. If members of this committee really want work to be done in the federal agencies, that's the issue that they should be looking at. They should be looking at the Trump administration and saying, what the heck is going on?
I-
We need people in these agencies.
Thank you. I couldn't agree more. Like, for us to underfund them, cut their staffing, and then point our fingers at them that they are failing is absolutely insane to me. I also wanted to ask you, much of your litigation experience has been focused on defending community groups from environmental harms. I would say it's not a secret side hustle or not changing outcomes when we stop raw sewage from going into the Willamette River. I would like to understand, what barriers do local groups face when bringing complex litigation against the federal government? Professor Rolfe.
Well, litigating in federal court against the Department of Justice is a very tall order, especially in complex statutory areas like environmental law. And if a small group with few or limited resources goes out and says, I think I'll find an attorney who could handle a case like that, they could go to a law firm, and that law firm indeed would say, sure, we will represent you, and the hourly rate would be at least $500. And so finding an attorney who will represent them for free is only possible with statutes like the Equal Access to Justice Act.
Thank you. And I also want to just highlight that this is pretty standard practice, that the legal fees are paid from the awards. And that is even true for our Social Security disability lawyers, who take on average 25% of the back payments that are due to the recipients. So they only are taking money that the recipient didn't receive from the federal government in the first place. So we could say that the secret side hustle is our government failing to actually pay our recipients. That is the vast majority of the cases that are being brought to us. Again, I will assert that if we staff our agencies appropriately and avoid the mistakes in the first place, that all of us will save our taxpayers money, which I agree is an incentive that we all should be driving for. So thank you very much. My time's expired.